Thank you very much, everyone. Let me take this opportunity and greet the Honorable Speaker, the Whip of Council, members of the Mayoral Committee, councillors of Govan Municipality, the media, stakeholders, and members of our community. Today we are here to communicate some of our decisions and the state of the municipality, in particular the council, and eventually communicate the intentions of us moving forward. The Council of Govan Mbeki was established on the 22nd of November 2021 after the elections that took place on the 1st of November 2021. The municipality is a hung municipality, as no political party was able to get an outright majority in the polls. The following parties took representation in the council with the following number of seats. The African National Congress, which got 26 seats, and Democratic Alliance, 17, Economic Freedom Fighters with 13, Freedom Front Plus with 13, with 3, ARP with 2, ATM with 1, IFP with 1. These numbers make up a council of 63 councillors. This therefore means that the government that was formed out of some agreements, but no coalition was formed at all. We, as the African National Congress, contested and won 3 positions out of the 4 elective positions. This then allowed us to then run the municipal executive authority, while another party does oversight. We took this as a good thing to happen, so as there can be transparency in all acts of the executive and administration. Unfortunately, we find ourselves in a very difficult situation, as we are not allowed to govern, but instead opposition wants to govern on our behalf, using our faces for their agendas that are not in the advantage of the municipality. We have since received many threats, both on our lives and also on the positions that we are holding. This even happened in council yesterday and also this morning by the chairperson of the EFF in the province today. Let us put it categorically clear, we are not born in these positions of being the executive mayors, the speakers, the whips and MMCs. If they want to govern, let them vote us out and we sit on the opposition benches, as long as justice will prevail for the people of Govan Municipality, not individuals. These actions to us have came as means to block us from unveiling the program of 100 days by the executive mayor, which includes, amongst many, unveiling the outcomes of the investigations that we had instituted and the imminent opening of cases against those who are implicated. Council has since set 5 times from the inaugural council, which out of the 5, 2 could not conclude its listed business in the agenda due to failure to agree on 2 matters, which are the motions that were submitted by the EFF. These 2 motions are mainly intended to reinstate the terminated municipal manager, Mr. S.F. Ndebele, and the second motion seeks to remove or pose a vote of no confidence on the executive mayor. Council, through its resolution, which is CA 16/07 of 2021, took a decision to terminate Mr. Ndebele's contract of employment as the relationship between him and the municipality had collapsed. This was after multiple processes of trying to resolve the matter between the 2 parties had failed, including internal disciplinary processes and court processes. Eventually, council resolved to terminate as this process was costing the municipality unnecessarily. There is a propaganda that continues to be circulated that we are in contempt of the court for not reinstating the terminated municipal manager. Let us put it categorically clear that we are not in contempt, but actually acted in the interest of the institution and the community of Govan Mbeki. This we did on the basis that the municipality was losing a lot of money, but at the same time we wanted to continue with investigations that we had started with. One of the investigations reports that we all know about is the Section 106 report, which was done by the Office of the MEC of COCTA, which it is said that we are not implementing the recommendations out of that particular report, but to the contrary, we would like to inform members of the public that we are implementing each and every recommendation of that report to an extent that we have opened a case with the Hawks early last year. Today, as we speak, the tender of sourcing a credible company to do a vetting of qualifications on all our employees is closing. We are going to fast track the process of appointment so as we can be able to hold accountable all those who are occupying positions without suitably qualified or suitable qualifications for those particular positions in line with the Labor Relations Act, since we will be dealing with employment issues. The other one is the illegal appointment of the vending company that we had since terminated as council. The company was appointed illegally and has costed us as the municipality lots of money, resulting in us having a growing account with Eskom, which today our account sits at about 3 billion owing to us to Eskom. Council took a decision to terminate this contract as it was irregularly or illegally appointed, and therefore we have since corrected this particular process and appointed a contractor that is fit for the purpose and suitably qualified. But it is important that we must inform members of public that this particular company has refused to leave the system and continues to vend, and which has led us to have a civil case against the company, and today we are going to open a criminal case against the company. That will subsequently affect the proceedings of the case of the municipal manager or the former municipal manager, whom is currently challenging the decision of being terminated at the CCMA, which is why we could not entertain the item in council since the matter is front of the judicial process. We are also intending to start with the implementation of the outcomes of the investigation or forensic investigation that we have done in the Govan Mbeki housing company versus Govan Mbeki municipality in terms of relations. The outcomes indicate that there is a lot that has not gone right, and the municipality has unfortunately made a serious loss with this particular relationship. This item is set to serve in the current or the supposed to have concluded council meeting, which will therefore be sitting on Monday to conclude its business. Therefore, some of the recommendations will warrant us to take serious action against those who are implicated both internally and externally. We are intending on opening as multiple cases as we can on the basis that the state of the municipality has degenerated to this level on the basis of negligence by certain individuals given responsibility, and therefore costed the municipality to be where it is. As we do all of this, we are doing it under oath, which we have taken when we took office with the magistrate of the court. Therefore, we are very adamant in ensuring that whatever that has gone wrong, we must correct it. If consequence management must happen to people, it shall therefore happen, but this shall not happen at the barrel of a gun by any other opposition party. Thank you very much. This is our communication for today.
So, Jana from the Richtstand, we would just like to know if what's happening with your 3 billion Eskom debt, if you made any arrangements or negotiations with them to pay it, and if so, how, what are those arrangements?
No, thank you very much. We had a bilateral meeting. Actually, we had a very broad meeting. It's not even a bilateral. We had a broad meeting where we hosted the senior management of Eskom on Wednesday as the municipality. Part of the meeting was Empower Machite and also labor representatives in our administration, together with the heads of departments that are affected, the MMCs. In that particular meeting, there were agreements that were reached, which we intend to conclude on implementation by the council that is scheduled for the 24th of February as to how do we assist each other, because all of us know that Eskom has currently serious challenges with regards to their financial viability and also their capacity to provide all of us with electricity as citizens of South Africa. Therefore, it is an obligation to all of us to pay our dues. Therefore, at the same time, ourselves as the municipality were faced with a similar situation where we are having debts and we are supposed to be able to pay. Therefore, there are plans that have been produced, including a service level agreement between ourselves and Eskom, which has not been signed because it must go through council first for approval, which therefore will serve on the meeting that is scheduled for the 24th. Therefore, we are going to give a detailed account once the service level agreement has been signed as to what is contained within that particular agreement. Thank you very much. Yes.
Okay, I'm Govan from Sescona Media. Looking at the Section 106 report, may you please tell us what has been implemented so far on the recommendations?
Yeah, it's quite a lot. It will take about 15 minutes if I report on everything. The first thing that you must note out of the report is that there are allegations of people that were not qualified that were appointed. And there were recommendations that, first and foremost, those which were appointed, particularly in the finance department, in the cashier section, must be monitored and be given capacity by the municipality in order for them to progress to the level where they are supposed to. And that has been done. And it is an ongoing process. It's not a process that will end now. Secondly, there are those that were given a particular time frame for them to conclude their qualifications. And that particular period is coming to an end at the end of March, if I'm not mistaken, end of March or end of February. And therefore action will be taken immediately after we find out whether they've been able to pursue and conclude on what was given to them. As I had indicated, we had already advertised for a suitably qualified company to do vetting on qualifications of each and every employee of ours, all 1,200 plus. Thirdly, we have written letters summoning companies which are highlighted there to come and be able to justify their relationship with the municipality. And some have responded, some have not. We've gone through the process of a second letter that was sent to them, and action is therefore due to some of them. It is also important to note that some of the companies decided to go to court for a review of the same report, and were waiting for the outcomes of that particular process. That includes some of the political office bearers which their names were touched in the section 106. But most important to note is that we have opened a case with the Hawks early last year, and therefore investigations are ongoing as we speak. Ourselves, we have since charged senior managers which we alleged to have wronged in the process of recruitment, in the process of appointment of contractors, and most of those cases have concluded. We have since also charged junior officials which were, their names were touched on, and those processes are ongoing as we speak. They have yet to conclude. There is quite a number of areas that I could touch on, but it will take a long time. I thought those are the prominent areas that you would want to touch on. The section 106 is a report that we are reporting on a quarterly basis to the office of the MEC, but at the same time we are reporting the same information to council. It is important to note that council, the last council which sat on the 6th, resolved to say that they would want to observe the information that is contained in the report versus reality. Therefore, the report was referred back for that particular process to be done. So as we don't mislead society in terms of what is it that has been done. Thank you very much.
Honourable Executive Mayor, there's 3 questions I want to ask. The first one I want to ask is, should motions be filed correctly, according to the standing orders? Would you allow them to vote as per democratic processes that should be followed in this country? The second one is, why did we take so long in getting to where we are with the 106 report? And then thirdly, why do we use, on the housing company, why do we use, and you and I have discussed this before, why do we use lawyers, lawyer firms, instead of forensic investigators to do the investigations into this? As lawyer firms, all they do is they will have a meeting and they will have a discussion with people, and they don't really go into the forensics of the... that brings us to why the 106 report has also got some problems in it. That's my 3 questions.
No. Thank you very much. I think the first question is motions. Motions are views of a particular councillor or more than one councillor that will be tabled in writing to council. They are prescribed by the standing orders, which are the rules that we run council based on. They are prescribed to follow a certain pattern. They should be submitted within a particular prescribed period, which is 10 days before the actual sitting of council, and therefore after they meet all the criteria, then council, with the leadership of the speaker, must therefore ascertain whether it's agreeing with the motion or it's not agreeing with the motion. Once the motion has been agreed upon, it depends on the nature of the motion, whether the motion is referred to the mayoral committee for the mayoral committee to process an item to council, or it's a process that requires council itself, a matter that is not delegated to the mayoral committee. When it comes to issues of voting, voting are also guided by section 28 of the same standing orders, which prescribes how we are supposed to vote and when do we vote. For example, I would want to touch on one of the issues that arose yesterday that said that a motion that said that they are raising a vote of no confidence on the speaker, which was an irregular motion on the basis that Section 40 of the Structures Act says that if you want to put a vote of no confidence and remove a public office bearer, you must therefore give a written notice prior to the sitting of council, which in terms of us as this particular municipality, it then means that particular motion must be submitted 10 days prior to the actual sitting, on the basis that the constitution of the country is the supreme law and guides all of us that we must be in a position of sub-laws that are going to guide the detailed process on how to implement the actual laws that are superior. Therefore, in terms of our own standing orders, a motion must be submitted 10 days before the sitting of council. Then council will then vote on the matters as such. Then on the issue of why did it take us so long to get to where we are with regards to Section 106. Look, we are running an institution which is guided by laws. For each and every action that you take, you have to follow the prescripts, otherwise you are going to mess up the process. That is one of the reasons that we find ourselves as the municipality with a situation where we have lost most of our cases. We have not lost our cases in terms of merit, but in terms of procedure in handling them. Therefore, with Section 106, we did not want to mess any process up. That is why we wanted to follow each and every step as we move forward. That is why it takes so long. For example, the issue of vetting, it required the budget to be allocated, because by the time the results of the outcomes of the Section 106 report were out, already council had adopted the budget and it had not allocated, as it had not anticipated that would be the outcome. Therefore, we had to start the process from budgeting. After budgeting, then advertise and go through all of those processes. We are also ourselves as council not pleased with the pace at which the pace is moving outside, which we do not have much influence in terms of our law enforcement agencies with the cases that we've reported. It's a matter of concern. Myself and the acting MM had a meeting with the officers handling Section 106. I think a day before the sitting of the meeting last week, not this week, last week, so as we could give progress to council, but only to find that progress was very slow on the side of the law enforcement agencies. Then on the last one, which speaks to the report on GMHC. Look, it has been a norm. Even ourselves, we took from those who are considered to be our elders a quota in this particular scenario. As they did Section 106 investigations, they utilized what is called law firms instead of forensic companies. So if it is being done at that particular level, our understanding is that it is doable even within our territory. That is why we looked for credible law firms that can be able to do the investigation on our behalf. I think that it is a matter that we must be able to consider in council. As we are going back in council with the same report, we must be able to say, moving forward, any investigation that is subjected to be a forensic investigation must be done by a forensic company accredited as such, so as we can be able to get the results that we are looking for. I personally agree that we must use forensic companies, because they can do much more than what law firms can do in terms of accessing people's bank accounts, verifying whether there were deposits and so forth, rather than the law firms that are limited in such and will not be able to reach as far unless they go to the court and get permission, which is therefore going to prolong the process and defeat the purpose in terms of the targets that were normally set by council. Thank you very much.
last question. There are allegations that the Ama guerrilla or Govan, they are paid to protect you. What is your response on that?
Well, the first thing that I will say is that municipality is paying for my protection. As we are seated here, they are outside the door for my protection. Maybe one must speak to the issue of forums. We are, as a municipality, a host to communities that are diverse, and they group themselves in various stratas. One of those stratas is the unemployment sphere. Also, you have the business sphere and others. In the recent past, we have had issues with business forums, which found themselves to be terrorizing administration within the municipality for work and other related matters. Also stopping projects that could not move, and all of those things, wanting the 30% stake of locality and so forth. The same is happening with the unemployment forums, which I would not want to speak to one. Myself, I have had meetings with all forums that I am aware of, and it has not been a matter of secrecy, as it was even published on some of your medias which are present here, that I have met with them. The purpose was to try and contain the situation which was getting out of hand, as the situation of terrorization of business was happening, including the municipality, as projects could not move. Now, if relations between the municipality and forums is good, therefore it can be taken as a means to attack the leadership that is present. We do not have bags of money that seek to pay in each and every individual for our protection. That is why I've raised it here officially, to say that we are not threatened by any threats that are delegated to us, because we are confident of our state security and law enforcement agencies. Now, for example, if you go to Leandra, there is a forum there. It's not Amagorilla, there is a forum there. And relations are good between ourselves and them after we had the situation where Leandra burned down. We have been meeting with them ourselves, including offices like the MECs of Human Settlements, COCTA, and others. Therefore, it cannot be reduced to individuals. It's stakeholders within our community that must be given attention and must be guided, because sometimes local leadership fail to play its responsibility as the leader of society and want to take matters into personal interest and personal direction. It is our responsibility as elected public reps to lead each and every body. Therefore, I am the executive mayor of Govan Mbeki municipality, not the executive mayor of the ANC, as I'm seated here. Thanks. Thank you very much, everyone.